All right. Hi, my name's Paul Mannion and I work at Mannion Lawyers. We run family law for fathers. So we're a family law firm that are focusing on dads. Primarily, that's what we do. So I've been looking at a Facebook page and it's designed to support and assist dads. And the Facebook page, I sent a post asking if people would be interested in me offering some advice, some legal advice from a lawyer's point of view. The response was overwhelming, so I thought I'd give it a crack and see what the views are. And basically, I'm happy to do a few of these, answer some of the topics, answer some of the questions, and then if the views stop, then I'll stop doing the videos. Look, I'm not a YouTuber. I'm not an influencer. This is all very new to me. I'm sure my grandson would have better knowledge about making these videos than I have. But anyway, we'll give it a go. It's not going to be edited, so it's not going to be cut and pasted. I'm just going to ramble on for a little while, and you guys can listen and turn off if you don't want to be. If you don't listen, that's fine. But just bear with me and some of my frustrations with videoing. Okay, a couple of disclaimers. I can't give everyone advice, of course, and I can't give individual advice in this format. So I'm looking at general questions and I'm giving general advice. So it clearly isn't specific to your case. It might be specific to a question that's raised that might be similar to your issue, but I'm not giving individual legal advice to every individual person watching. Okay, the other thing is I don't intend at this point to be able to, like physically able to respond and address all the comments that I might get on these videos. I just physically don't think I'll have the capacity to do that. I'm obviously running a law firm and I still have a caseload, and I have responsibility to my clients to be able to do that. We'll see how it goes. I'll try and have a look, but see what the responses are like. Okay, so the Facebook page was Dad's Rights Australia, and I sort of tapped into this and seeing a lot of heartache, naturally, a lot of heartache and a lot of pain and a lot of anguish. I also saw a lot of anger, which I understand is there, and I understand why people can be angry about situations and hurt about situations. And I understand that because I've been through the process myself. Before I was a lawyer, I've been through the process myself. So I can appreciate that there is that anger. But I can tell you that anger is not going to help you at all in these matters. The most successful clients that I've had are the people that have maintained a calm and steady attitude and responses to all the horrible things that happen in family law court, and communicate as best and effectively as they can. The most complex, or not even complex, the most difficult cases I've had are the ones where there's just anger, and the anger is so overwhelming that the clients are not able to see what they need to do so that they can progress the matter further. Okay, so I guess that's part of the reason why I'm not going to reply to some of the comments, is because I can understand that there's a lot of anger in there and people will agree or not agree with what I'm saying, and that's fine. And of course, it's your choice. You don't have to follow or listen, or you can just turn off. That's the other thing I'm not doing. I'm not asking you guys to subscribe. This is not a money-making thing. It's just a video to help some clients out, or help some guys out or people out when they've got family law matters. So I intend to answer a couple of questions, ramble probably too much, but answer a couple of questions and then we'll take it from there, how we go. Okay, one that came up recently is name changing. I saw that a father was talking about the mother had actively changed the name of the child. So legally that can't happen. Legally both parents have rights in relation to the name of the child, and you can't change a birth certificate without an order, without consent for starters, or without an order. Now, the Family Law Act has shifted a little bit in the last few years and moved from joint parental responsibility being the go-to position for the court to sole parental responsibility. And a couple of things that I've seen in the past is when a party, mother or father, have sought sole parental responsibility and in fact got sole parental responsibility, that gives them the right then, if they choose to change the name on a birth certificate. And it's a horrible thing, and it's one of the allowances in certainly the cases I've seen. It's some of the allowances that have been given, especially perhaps a hyphenated name, so that the father can spend time with the kids. So, family law is full of deal making all the time. You can go all the way to a final hearing and then there'll be deals made. And no one will be put on the stand. There'll be deals made. It's very frustrating. But that was one of the deals that we saw. And it was, the father was comfortable with that if it was a hyphenated name. And I guess hyphenated names these days are not a big deal. But if the mother is seeking sole parental responsibility, you can add a clause in your order that, sure, sole parental responsibility, however, a clause that the name is not changed. And that will be agreed to or not agreed to. If it's not agreed to, then the judge will make the decision, and you're left with whatever the judge decides. Okay, so that's the parental responsibility name changing part. I'll add another one because I don't intend for these videos to go on too long, because I'll probably end up stuffing them up and I don't want to have to go back and re-record the whole thing. So I'll give you another one about false allegations. It comes up a lot. A lot of parents, a lot of people are commenting on false allegations. It's one of the most frustrating things in family law because false allegations are prevalent. It annoys me as much as it annoys you guys, because affidavits aren't challenged until final hearings. So no one gets on the stand at an interim hearing. And so what happens is a person, a mother or a father, will say these things and give the court an impression about what their concerns are. Notice of risk, for example, what the risks are. And then the court really, I sympathise with the court as much as it's frustrating, and I can see that it's frustrating for my clients all the time. I sympathise with the courts because they have to. They have no choice but to err on the side of caution. Until the evidence is challenged, they'll always have to err on the side of caution. And it is very frustrating. So false allegations are going to be, may be made in their initial affidavits, and it's not until they're put on the stand and they can be questioned and challenged, but they're not going to be put on the stand during interim hearings. And interim hearings are when you get some interim orders in relation to time with the children. And interim orders are really, really important because they can go on for 12 to 18 months sometimes. So it's really critical that you get positive interim orders. Now, to address false allegations, I guess the questions I ask my guys when I talk to them, because this is the trifecta, it really is. When did you get out of jail? When did you get out of rehab? And when did you get out of the psych ward? Now, they're the three allegations that people are going to make towards fathers all the time. So knock them on the head, like get them sorted. If you've, and of course the answers are usually no. Sometimes there's, a lot of my guys have a apprehended violence order against them, and almost all of them are suffering anxiety and depression. It's just part and parcel with family law, unfortunately. So get your counsellor to write you a letter. No risk, not a danger. Seeing a counsellor, that's fine. If drug and alcohol is a history, then think about getting a hair follicle test before court starts and see what it says. Or get one that shows negative and put it in your initial affidavit. That's the best thing you can do. Try and assume what the allegations are going to be made, and then try and counteract them straight away in your initial affidavit, and provide evidence. Because if you provide evidence that this hasn't happened, they can't provide evidence that it has. Unless there's, admission to a psych ward or rehab admissions or police reports. because the court's going to look at police reports anyway. The first thing court's going to do is look at criminal records and child protection records. So any police events and any child protection records. So my advice when I'm talking to blokes is try and mitigate all these allegations as quickly as you can with evidence. So when the court's looking at two pieces of paper, one's got all these allegations with no evidence, and the other one's got all these counter allegations or addressing the allegations with evidence, then it gives them the break that they can, and they don't necessarily need to err on the side of caution because they've got evidence in front of them. All right, that's longer than I thought the first one would go on to. Let's see how we go in the future.